Hello, everyone, and welcome to Uncivil Law. I hope you are having a good day in these trying times. And we are here with another edition of Supreme Court React, and we are going to do a foundational gun rights case today. Some people have been asking me to do some gun rights cases, and I'm happy to do gun rights cases, and I figure we'll go back and we'll try to understand Miller. Now, Miller is to me, and it's been a long time since I read Miller, so we're going to find out if I still find it as confusing as I did. But when I read this in law school, so many years ago, I found this to be probably the most confusing case I read. By that, I mean that even after I understood it, I didn't. Because there's certainly cases that were more difficult to parse, or cases that use more challenging language, or cases that are written in a different style. And so there's cases that are hard for different reasons. But this one I found just inherently contradictory. I found it to be not really standing for any clear proposition. It was just not really, really hard to, not really easy to deal with it. It was a big mess. So I'll give you a little bit of a background about some of the facts on this case. So we can start with that. First of all, who Miller was himself. So Mr. Miller is Jackson Miller. He was a gambler, roadhouse owner. So if you ever seen that movie, Roadhouse, he was that guy. And a small-time hoodlum from Oklahoma. He was born in about 1900, and he grew into a thug, and by 1921, his 21st birthday, he was in trouble with the law. 1924, he accidentally killed a court reporter when he was working as a bouncer, so that was good. Miller did not hit the major leagues of criminal law behavior until he joined a gang in 1934, presumably as a result of the Great Depression. In 1934, he robbed two banks at the same time. On December the 22nd, 1934, robbed two banks at the same time. Okay. And yeah, by all amounts, he got away got away with it. So one of the few times there was a double bank robbery that was successful. So good. He got about $20,000 from those two bank robberies. Of course, that's 1939, $20,000. So there's a little bit more than that. He returned to Claremont, Oklahoma, with his share of it, which was $2,000 because it was a part of a gang. And police eventually arrested him. In 1935, he apparently didn't learn his lesson. He robbed a bank in Arkansas, stealing $22,000. And then, meanwhile, the FBI was busy indicting and arresting some of his people, and he turned state evidence, so he became a snitch for the job that later one. Yeah, the Miller got complete immunity for his testimony. Good for him. So skip a little bit forward. Okay, and then in 1938, the Arkansas State Police stopped Miller and Lamont outside of Arkansas en route from Oklahoma, and on their person, they had an unregistered short-barreled shotgun in the car, apparently making preparation for another armed robbery, so the police arrested him. So that is the crime that we're interested in at the moment, is the possession of the short-barreled shotgun crossing state lines on April 18th, 1938. Not his first run-in with the law, but that's how we got there. He was indicted for violating 26 U.S.C. 1132 at the time, transporting an untaxed short-barrel shotgun in interstate commerce. And it became a Second Amendment case under the National Firearms Act, which was 1934 Firearms Act, which regulates these things. Short-barreled firearms are considered a regulated firearm in the same category as a silencer, in case anyone's interested. So it's not illegal to possess it, but you do have to pay the federal government money and get tax stamps and all the rest of it. So you get to pay them government money to own this. So that went forward as a test case because the government, there was no case really upholding this before. So Miller was going to be the case upholding the National Firearms Act. So it's a pretty big deal for that. The National Firearms Act had just been passed, and he was going to be the test case for this. And the test came quickly. 1939, they appealed directly to the Supreme Court. So a year later, not even a year later, they appealed it to the U.S. Supreme Court after the trial on a direct appeal. So they bypassed the Court of Appeals. So that happens sometimes, right? It's called certiorari before judgment now. So they decided to bypass the Court of Appeals, go straight to the U.S. Supreme Court. Fantastic. The Solicitor General argued it. And then there was a whole kerfuffle. The things didn't get the brief, didn't get sent. They heard oral arguments on it, and Justice Douglas was not yet confirmed at the time, so he didn't hear the case. Gordon Dean represented the United States, and no one represented Miller or Layton. So perhaps due to problems, but only the U.S. government argued the case. And then a month and a half later, they came out with their 8-0 unanimous opinion. So that is a brief history of the case. So that's what happened. Yeah. Oh, in case you're wondering, I had to go back and read why Miller wasn't represented. In case you want to know why, Miller's attorney wrote on a telegram on March 28th. This is 2 days before the oral argument. He wrote on a telegram, suggests case be submitted on appellant's brief, unable to obtain money from clients to present an argue case. So the lawyer didn't show up because he hadn't been paid. I'd just like to note for the record, today, that would definitely not fly. Today, you'd have to go and argue the case and argue about the money later. But in 1938, apparently, you could just telegraph the Supreme Court on March 28th and be like, I didn't get paid, so I'm not going to come, and they'll still have oral arguments 2 days later. That would not happen today, just telling you. So, whatever he did with all his bank robbery holdings and stuff, he didn't hold enough to pay his lawyer, or he decided not to, or whatever. So only the U.S. government argued the case. So that is the brief history of Miller. Very exciting. So now we're going to read the Miller decision, and we're reading this as it was printed in the U.S. reports. So we're just going to read it from the page. This is how it's printed, or was printed in 1938. Yeah, so this is an appeal under the Criminal Appeals Act from judgment and sustaining a demurrer to an indictment. Okay, great. Jordan Dean argued the case. The Solicitor General were on brief. No appearance for appellees. I don't know, Matt. I don't know if I've ever seen a U.S. Supreme Court case, or really any case ever, where they say there's just no appearance for one side. No appearance for appellees. So I think that's part of the reason this case is so messed up, is because it's just, yeah, it's fine. I don't know if he was dying, but he didn't pay his attorney. That's what was happening. All right, Mr. McReynolds delivers the opinion of the court. It's been a long time since I read this, and last time I read it, I found it very, very confusing. So we may pause a lot as I try to work my way through this morass. So we'll see if it's confusing as when I read it like 20 years ago. Let's find out. An indictment in the District Court of West District, Arkansas, charged Jack Miller and Frank Layton did unlawfully, knowingly, willfully, and feloniously transport interstate commerce from the town of Claremont in the state of Oklahoma to the town of Siloam Springs in the state of Arkansas a certain firearm, to wit, which is fancy legal talk for, that is, a double-barrel 12-gauge Stevens shotgun having a barrel less than 18 inches in length, which incidentally is the same requirement today for a short-barrel shotgun. It's still 18 inches. Bearing identification number 76230, so it has serial number. That's good. Said defendants at time of so transport transporting said firearm in interstate commerce as aforesaid, as we just told you, not having registered the firearm as required by Section 1132 of Title 26 of U.S. Code, and not having in their possession a stamp affixed written order for said firearms as presided. They didn't have the stamp. It's a stamp, like you get from the post office, except it's a lot more cumbersome. But it's a stamp, yep. So they didn't have the stamp. And regulations issued under the authority of Congress, known as the National Firearms Act, approved June the 26th, 1934, contrary to the form of the statute in such case, and provided as against the peace and dignity of the United States. Okay, fine. A duly interposed demur alleged. The National Firearms Act is not a revenue measure, but an attempt to usurp police power reserved to the states, and therefore is unconstitutional. Okay, I mean, I don't know how good this argument was in 1934, but, today this argument wouldn't be so good. When was Wickard v. Filburn decided? V. Filburn, 1942. Yeah, so Wickard v. Filburn hadn't even been decided yet. So the idea of the government's ability to do everything under the power of interstate commerce or everything under the power of interstate tax had not yet been established. So this argument was a lot more workable in 1938 than it would be later. But yeah. Also, it offends the inhibition of the Second Amendment to the Constitution. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So he says, this isn't actually a tax. So he's making two arguments. First, despite the form that it's in, it's not really a tax. It looks like a tax, but it's not really a tax. It's really an attempt to usurp police power. Again, this argument would be a lot better in 1938 than today. And it's also an argument that, it violates the Second Amendment, which would also be a better argument than today. So both these arguments, yeah, but that's what he's arguing. Okay, fair enough. I understand these things. The district court held that Section 11 of the Act violated the Second Amendment. So the district court said it did violate the Second Amendment. It accordingly sustained the demur and quashed the indictment. Okay. This case is here by direct appeal. Fine. So he won. Miller won at trial. It got direct appealed. Okay. And they didn't pay his attorney or something. I don't know, man. It's a weird case. It's a weird case. Considering Shalinsky versus United States and what was ruled in sundry causes arising under the Harrison Narcotic Act, the objection that the act usurps police power reserved to states is untenable. Okay. You don't show up in the subscribers feed, senpai? I don't know what to do about that. I mean, what do you want me to do about it, right? It's public, right? So because you're watching it, so I don't know what to do. I'm not posting it on Leonard's stream. I'm not posting every one of these things on Leonard's stream, guys. I'm just not doing it. I want to start my own, thing. So I don't know what to tell you. I mean, I posted it 2 hours ago, so it would have plenty of time to circulate. I don't know if it showed up on Facebook or showed up on Twitter, but those are the only other mechanisms I have. I'm not posting all these things on Leonard's channel. I'm just not going to do it. In the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time having some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say the Second Amendment guarantees the right to keep and bear such an instrument. Certainly is not within judicial notice that this weapon is part of any ordinary military equipment or its use could be contributed to the common defense. So, okay, I assume by judicial notice, they mean judicial notice. So what judicial notice normally means is it is something that is so readily clear that the court can just take, it's a statement of fact, but it's so clear and so unambiguous that, that you don't have to have a witness to put it forward before a court. So, if you're before a court and you want to argue a fact, right? Normally you do this by offering a witness who will testify to the fact. But some facts are so clearly established that we don't need anyone to testify to it. It's just it's just clear. So, I don't know. Carbon is a element on the periodic table. Do we need to bring in a chemist for this? No. It's like we'll just take note that carbon's on the periodic table. If what you're trying to prove is carbon's on the periodic table, we'll just accept that judicial notice. So they're saying, well, this isn't acceptable by judicial notice. Now, I would like to take note here that this doesn't mean that it's not true. There's a difference between judicial notice and true, right? So something can be true, but not inside judicial notice, which you'd have to bring a witness for. So a lot of people will say, well, short barrel shotguns are military equipment. They were used in this conflict, that conflict, whatever. So that's not the same thing. The court is just simply saying it's not so obvious to us that we can take judicial notice of it. And, fair enough, that it was used in some military conflicts, I have no doubt. That it would be like blindingly obvious to any judge, in 1938. I don't know. If you asked me to take judicial notice of it, I probably wouldn't take judicial notice of it. So I'm just saying that, it doesn't quite fall into that category. The Constitution, as originally adopted, granted Congress's power to provide forth the calling of the militia, to execute the laws of the Union, to suppress insurrection and repeal invasions, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of officers and authority of the training of the militia according to discipline prescribed by Congress. With obvious purpose to assure the continuation and render possible the effectiveness of such forces, the Declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that end in view. Okay, so far so good. Yeah. Yeah, I couldn't say for sure, but I would imagine if you give the stream a like, I would imagine if you interact with the stream, and I would even imagine if you give the stream super chats that YouTube might take better notice of the stream, because YouTube is getting money from it. YouTube likes money. So I would imagine that this would help. Just as, like, comment, subscribe, and if you can, give super chat, because YouTube might, say, hey, we're getting paid from this, and might promote it accordingly. I don't know that for a fact. Just seems like something they're probably taking into consideration behind the scenes, I would guess. The militia with the states were expected to maintain and train is consistent with the troops which they were forbidden to keep without the consent of Congress. A sentiment of time strongly disfavors standing armies. Fair enough, they did. The common view was that adequate defense of the country and laws could be secured through the militia, civilians primarily, soldiers on occasions. Fair enough, yes. The original Constitution was a bit skeptical of standing armies, yes. The signification attributed to the term militia appears from debates in the Convention, the history and legislation of colonies and states, and the writings of approved commentators. I don't know who that is, but okay. These show plainly enough the militia comprised all males physically capable of acting in the common defense. So, this is helpful to so this is a line that's helpful to gun rights advocates, right? So it's like, well, what is the militia? Because it says a well-regulated militia being necessary to security for states. So what is a militia? Well, this part is helpful to gun rights advocates. Militia comprises all males capable of acting in concert for the common defense. That's the Militia Act of 1797, I think, that says that, which I think is still in the books today, incidentally. It's all males between 17 and 45, I think, which means that I'm still in the militia. Kick ass. So, yeah. So that's good for gun rights advocates. Like, who is the militia? All the men. And, today, because of equal rights, presumably the women too. So, that's fine. A body of citizens enrolled for military discipline. And further, that ordinarily when called for service, these men were expected to appear bearing arms supplied by themselves and the kind more common use at the time. So again, this goes to one of the philosophies of the Second Amendment, which I've talked about before. One of the ideas is that, the arms that you'd be bringing are the arms that you're familiar with, right? So when we talk about the right to keep and bear arms, I say, well, what kind of arms are protected? What kind of arms are protected? And this is part of the language that is getting at this idea. The ones that are protected are the ones that are keepable and bearable, the kinds that are in common use at the time, the kind that you would have familiarity with on a somewhat routine basis. whether that's for hunting or whatever other purpose. The idea is that, the church bell is ringing and you're bringing whatever it is from your home that you have some familiarity with so that you can deploy it as part of the militia. Because, you're a civilian and now being conscripted essentially into service. And you're being conscripted with whatever you can bring. Bring your own gun, right? So what I've said before is the Second Amendment protects the arms that are capable and bearable. So an arm does not include a nuke. It doesn't include a nuke because it's not capable and bearable. Because no one would be using it for an ordinary and common purpose. Because that would be dumb. So no one has familiarity with it. So, that doesn't apply. So the ones that are protected are in common use. And you see this language again mirrored in Heller. So, that's what it's talking about. Blackstone's commentaries point out that King Alfred first settled a national militia in this kingdom, referring to England, and traces of subsequent development and use of such forces. Adam Smith's Wealth of Nations contains an extended account of the militia. It is said there, men of republican principles, that's small r Republican, right? In other words, we have a republic, not a king. Men of republican principles have been jealous of a standing army as dangerous to liberty. Yeah, they're concerned about a standing army because they think it might hurt their liberty interests. Fair enough. In a militia, the character of the laborer, artificer, or tradesman predominates that over the soldier. In the standing army, that of a soldier predominates over every other character. And the distinction seems to consist the essential difference of the two species of military force. So yes, why is a militia good and why is an army good? Well, a militia is good because it's ordinary people, and an army is good because it's not. And so, the degree to which they are desirable depends on your end goals, but yeah, makes sense, right? The American colonies in the 17th century affirms in reference to an early system of defense in New England. In all the colonies, as in England, the militia system was based on the principle of the assize of arms. Assize of arms. Okay, Google, what is assize? Okay, Google, stop. I didn't ask Google for meth. That was not what I was asking. Let's try this again. Okay, Google, what is aziz?
According to Wikipedia, aziz in Arabic is derived from the root zizi with a meaning of strong, powerful, and the adjective has acquired its meaning of dear, darling, precious. It is a cognate of Hebrew oz.
Okay. Okay, Google, stop. So, dear, precious. The principle of the preciousness of arms. Kick ass. I like that. I'm going to have to start using that in my language. The principle of the aziz of arms. Precious, dear. That's kick ass. I like that word. That is now a candidate. That's a candidate for one of my favorite words. I like that word. In case you're wondering, my favorite word of all time right now is the word dragoon, because I just think it's badass. But this word's pretty cool. I like this aziz or aziz. I may have to adopt this in everyday speech. This is cool. This implied the general obligation of all adult inhabitants to possess arms, and with certain exceptions to cooperate in the work of defense. The possession of arms also implied the possession of ammunition, which again is another nice point for gun rights advocates everywhere, right? So we're not going to ban your guns, we're going to ban your ammunition. Oh, but one implies the other. Right. And the authorities paid quite as much attention to the latter as the former. Right. Which is as true today as it was then, right? Why ban the guns when you can ban the ammo? Right? That's pretty effective. A year later, 1632, going back, it was ordered that any single man who had not furnished himself with arms might be put out of service and thus become a permanent part of the legislature of the colony of Massachusetts. Are they threatening to throw people out? They're threatening to throw you into the wilderness. They're threatening to throw you out. They're threatening to just throw you out into the wilderness of Massachusetts, as of 1632, because you won't take up a gun. So take up a gun, or we're going to banish you to Massachusetts. Okay, which I guess makes sense, because if you won't take up a gun, we'll send you to a place that doesn't like guns, which I guess is as true in 1632 as today. Yay. Also, clauses intending to ensure the possession of arms and ammunition by all who are subject to military service appear in all but the important enactments concerning military affairs. Fines were the penalty for delinquency, whether of towns or individuals. According to the usage of times, the infantry of Massachusetts consisted of pikemen and musketeers. The law, as it enacted in 1649 and thereafter, provided that each of the former should be armed with a pike, corselet, which I don't know what that is, headpiece, sword, and knapsack. Knapsacks are important, I guess. The musketeer should carry a good fixed musket, not under bastard musket bore. What the hell is that? Not under bastard musket bore. Wow. I don't know what that is exactly. Carry a good fixed musket, not under bastard musket board. Okay. Not less than 3 feet 9 inches, nor more than 4 feet 3 inches in length. Okay. A priming wire, scour, and mold. A sword, rest, bandolier, 1 pound of powder, 20 bullets, and 2 fathoms of match. I didn't know that you could measure matches in fathoms. I thought fathoms was a measure of depth in the ocean. Isn't fathom a measure of depth in the ocean? What the hell is a fathom of match? What is that? Law also required that 2/3 of each company should be musketeers. The General Court in Massachusetts, January session of 1748, provided for the organization and government of the militia. It directed that the trained band should contain all able-bodied men from 16 to 40 years of age, and the alarm list, all other men under 60 years of age. Fathom is a length at 6 feet. Noted. Okay, I am a fathom tall. I guess I'll use that in my dating. I'll use that in dating from now on. If I'm online dating and a woman asks, "How tall are you?" I'll say a fathom. It should go real well. It's directed to train band. Okay. Every non-commissioned officer and private soldier of the militia, not under the control of parents, masters, or guardians, and being sufficiently able in the judgment of selectmen of the town in which he dwell, shall equip himself and be constantly provided with a good firearm. These are laws I can get behind, man. This is good stuff, man. By an act passed April the 4th, 1786, the New York legislature directed every able-bodied male person being a citizen of the state or any of the United States and residing in the state, except such persons are hereon excepted, and who are of age 16 and under the age of 45 shall, by the captain or commanding officer of the beat, in which such citizen shall preside within 4 months of the passing, be enrolled in the company of such beat. That every citizen so enrolled and notified shall, within 3 months thereafter, provide himself at his own expense with a good musket or flintlock, a sufficient bayonet and belt, and a pouch with a box therein to contain not less than 24 cartridges suited to the bore of his musket or flintlock, each cartridge containing a proper quantity of powder, ball, 2 spare flints, and blanket and a knapsack. Knapsack. There's that knapsack again, man. So, the legislature of New York has somewhat changed its mind over the years. The legislature of New York, circa 18th century, said every male must buy a gun. It's changed a little bit. The General Assembly of Virginia, 1785, declared the defense and safety of the Commonwealth depend on having its citizens properly armed and taught of the knowledge of military duty. Yeah. It further provided the organization and control of the militia and directed that all free male persons between the ages of 18 and 50, with certain exceptions, shall be enrolled or formed into companies. There shall be a private muster of every company once in 2 months. So, like, every 2 months, they'd, like, make you show up and do some sort of drilling. Every male in the entire state. Yeah. Every officer and soldier shall appear at respective muster field on the day appointed by 11 o'clock in the forenoon. In the forenoon? Wow, that's a nice expression that I don't know that we have anymore. Because obviously the alternative to forenoon would be afternoon. noon. So that's a hell of a way to say morning. Forenoon. Okay. 11 o'clock in the forenoon, armed, equipped, and acculturated as follows. Every non-commissioned officer and private with a good, clean musket carrying an ounce ball and 3 feet 8 inches long in barrel, with a good bayonet and iron ramrod fitted well thereto. A cartridge box properly made to contain and secure 20 cartridges fitted to his musket. A good knapsack. There's that knapsack again. And canteen, and moreover, each non-commissioned officer and private shall have at every muster 1 pound of powder, 4 pounds of lead, including 20 blind cartridges, which I assume means blank, and every sergeant, nice spelling, shall have a pair of molds fit to cast balls for the respective companies to be purchased by the commanding officer out of the monies arising on delinquencies. So they would bring their own lead in bar form, and then you could use this mold to make balls like on the battlefield. Provided the militia of the counties westward of the Blue Ridge and counties below thereto shall not be obliged to be armed with muskets, but they may have good rifles with proper accoutrements in lieu thereof. Okay. And every one of said officers, non-commissioned officers, and private shall constantly keep the aforementioned arms, accoutrements, and ammunition ready to be produced whenever called for by his commanding officer. If any private shall make it appear to the satisfaction of the court hereafter to be appointed for trying delinquencies under this act, he is so poor he cannot purchase the arms herein. Such court shall cause them to be purchased out of the money arising for delinquents. Badass. Badass. So not only is every male within the range required to buy one, but if you can prove you're too poor to buy one will be provided for you. You have the right to a lawyer, and one will be provided for you if you can't. And you also have a right to a gun. And if you can't afford one will be appointed to you by the court. That's a Miranda warning I can get behind. You have a right to a gun. If you can't afford one will be provided to you at state expense. Best Miranda warning ever. Oh, man. Matt, this is way before Gideon versus Wainwright. That's a 20th century decision. We're like in the 1600s, Matt. The idea of a lawyer being provided for you has not even been dreamed of by anybody yet. It was just my point that, like, you know, it's like this is the 17th century equivalent of Gideon versus Wainwright. So 20th century Gideon versus Wainwright is the one that says you have a right to a lawyer. 17th century equivalent of Gideon versus Wainwright says you have the right to a gun. If you can't afford one will be provided to you. Yeah, this is great. Yeah. Frank says he wants his free gun. Me too, man. Me too. Most, if not all, the states have adopted provisions touching the right to keep and bear arms. That would be concerning or involving, right? Differences in the language employed in these have naturally led to somewhat variant conclusions concerning the scope of the right, but none of them seem to afford any material support to the challenge ruling of the court below. Okay, so none of the states have anything on point yet. In the margin of some of the more important opinions and comments by writers are cited. We are unable to accept the conclusion of the court below and challenge must be reserved. All right, well, you know, it's just, that's a little short. Yeah, it feels a little short because, like, we didn't really get to anything. We just went over all this history. The conclusion is a little short. So the conclusion is differences in language employed have naturally led to, but none of them seem to afford any material support for the challenge ruling of the court below. So, okay, so basically the Supreme Court is saying here that the court below says this is a Second Amendment right. And then the Supreme Court in its entire analysis section. So again, I'm having the same kind of problem I was having with the Katy Perry decision from the district court, is we did great issue, great rule, and we skipped the analysis. And so the Supreme Court kind of did the same thing. We had a good statement of the issue. It wasn't like outstanding, but it was okay. We had a reasonable statement of the rule, and then our analysis sucks. So our analysis and conclusion is contained in one paragraph. Our analysis and conclusion is contained in one paragraph. Most, if not all, the states have adopted provision touching the right to keep and bear arms. Translated, the states have had laws concerning guns. Deep. Differences in the language employed have naturally led somewhat varying conclusions concerning the scope. The states' laws are different, so there is some debate about how far they can go. But none of these laws seem to afford any material support for the challenge ruling of the court below. The court below said this is a Second Amendment right, but none of these legislative acts would support that, which, you know, is a bit of an odd sequitur today. I can't say it's a non sequitur, I guess, because first of all, the Supreme Court wrote it, so I guess that definitionally means it makes it a sequitur. And second of all, it might have been more of a sequitur than it is now. But basically said, okay, the states have regulated guns, and none of these regulations from the states say, therefore, that the district court was correct in saying this is Second Amendment right. Which is like, I don't know, touch me in the morning and walk away. I'm very unsatisfied here. I'm very unsatisfied. It's like, okay, and therefore what? Well, therefore nothing. That's the end of the case. You know, it's like, okay. In the margin of the more important opinions and comments by writers are cited. In the margin of this opinion, some of the more important opinions and comments by writers are cited. So here's a whole bunch of things other people have said. Okay, and we're not going to like describe them in any way, but here's a whole bunch of things other people have said. Okay, we're unable to accept the conclusion of the court below and challenge the judgment must be reversed. Well, that is deeply, deeply unsatisfying. That is just levels of unsatisfying. I don't. Yeah, this case is a strange one. Is a very, very strange one because it's just completely unsatisfying. It's like, oh, all the states have these varying regulations, and therefore we can't abide the concept that the district court was right. That doesn't, yeah, to me that doesn't flow. It doesn't flow today. So I was like, I don't know, that's like, I don't know.